On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us for some of our year-end review programs to start out this week, this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
Silly question to start out with. This time of year, annually, we look back at and review some of the cases in ag law and tax during 2022. I got to assume you've not ever had there's never been a boring year concerning ag law and tax that you've probably had ever, as far as developments are concerned.
No, and related to that, you'll find this interesting on my daily 2-minute show, which I'm pleased that WIBW runs. My marketing manager, when I started that a year and a half ago, asked me, "Were you going to have enough stuff to produce a show every single day?" And I chuckled. And right now, I'm 400 and I think I'm 460 shows in with no repeats. Or very few repeats. I've tweaked a couple because of court changes, but no, you just wake up each day and it presents itself to you.
Yeah. Oh no. And point being, and this is where we're probably going to go 2, 3, potentially even 4 shows just to talk about what happened in 2022. And let's get things kicked off.
Yeah.
And there are several things we can look at. One of the things I want to look at right out the bat, and that you and I have talked about ad nauseum throughout of this, is the, as you put it, and you're correct, the misnamed Inflation Reduction Act. And this has, of course, several tax provisions, but also things that were thrown at various ag programs as well.
Yeah, there was a lot of money thrown at ag programs. Of course, it's basically the Green New Deal that's scaled down a bit and tweaked. It's got a lot of these energy credits in it for electric vehicles, and of which, starting on January 1, there are 72 electric vehicle models that are none of which will qualify for the full credit. On January 1. I think only 24 will qualify for a partial credit. So, that's one of the things that I kind of, based on something the IRS did last week, and I'll mention this second, I kind of expect the administration to come out and just tell the IRS, let them have it anyway. What does the law matter when we don't have to follow it? That was a lot of what happened in 22, and related to that last week. And this drives my students that have taken administrative law absolutely nuts because they don't understand this, they don't realize this, and often the administrative law course doesn't talk about what IRS does, and so they get kind of stunned when they come to my course and they learn that IRS just kind of does its own thing often, and just totally violates administrative procedure law all the time. Well, last week they came out on Friday when nobody was looking. And Greg, there was this rule that's out there, and you have, it's called the Third-Party Settlement Organization rule, and these third-party vendors such as Venmo and PayPal, they're supposed to issue a 1099-K when transactions reach a certain level. Well, that had been $20,000 or 200 transactions during the year. So that means there's not really going to be a whole lot of 1099-K issued. No, that's an information return that gets issued to IRS and to the individual that's using the service. Well, Congress last year in the American Rescue Plan in 21 reduced the threshold to $6 and no number of transactions limit. They just came in and just said, anytime you're over $600 as a threshold amount, then the 1099-K is going to get issued. So that the information return is going to go to the IRS. So the Congress was thinking, well, there's a lot of this income that gets unreported because if these people are not being issued a 1099-K, they're not reporting the income. So we're going to require all of that to make the threshold really low. Well, last Friday, IRS came out and said, Friday afternoon, came out and said, nah, we're not paying any attention to that until 2023. We're just going to blow that off for 2022. And so don't worry about that. Well, here is the agency just looking at an act of the Congress and saying, nah, we're not going to do it. If you don't give us any straw, you don't get any bricks. And so that's, the agency does that all the time. They did this with P years ago. You probably remember 20 years ago, and I was involved in the litigation on that. And IRS just came up with a rule. Didn't go through the administrative process to publish a proposed rule and set it for a notice and hearing, and then get comments on it and then publish your final rule. No, they just said, all CRP payments are subject to self-employment tax. We don't care what we've said in prior history going back to the 1960s on the precursor to CRP. If you signed a CRP contract, you owe self-employment tax. Well, no. And I was the one that wrote the brief for the Eighth Circuit in the Morehouse opinion, and we got that reversed basically because my point in that one was, look, you can write your rule, but you have to go through the Administrative Procedures Act to do it. You have to follow the rules that Congress laid down. So we stopped them on that one, but they still do this kind of stuff. And that's a big one for people. And another one, Greg, and this is going to be a surprise for some people on their 2022 tax return that we're coming right now. We're about a month away from the start of the tax filing season, and that has to do with the child tax credit. This is going to hit farm people and non-farm people alike. Well, during the virus years, the Congress enhanced the child tax $2,000 up to $3,600 for kids under age 6. For those under age 18 but over 6, it was $3,000. The legislation, this omnibus bill that was passed on Friday that's now going to get signed into law that's got all kinds of stuff in it, that did not get renewed. And so now you revert back to your pre-virus years, and that's only a $2,000 credit per child. So some people are thinking, okay, I'm going to get a $3,600 credit. I got 3 kids under age 6, so that's 3,600 times 3. No, you're going to get 2,000 times 3. So you're losing 1,500 plus 1,600 plus 1,600. Your tax bill just went up by $4,800, and these people are not going to realize that until they see that their refund is a lot less. And then they're really upset with their practitioner, wondering, well, what did you do? What did you screw up on my return? Well, they didn't. It's just that the Congress did not renew that. So that's a surprise that's out there for a lot of people, too. But on this Inflation Reduction Act, they did throw a lot of money at various ag programs, the conservation-type programs, and all kinds of things. And so that will influence the types of things that farmers and ranchers do on the farm that could qualify for these tax incentives. So we'll have to see how that shakes out in the future.
This, of course, is the same IRS that, and correct me if I'm wrong, if Inflation Reduction, that they also the administration wants to hire 80,000 people for the IRS too.
Yeah, the bill has $80 billion of funding for IRS to allow them to hire 87,000 agents. Now, the thing to keep in mind on that is through attrition by 2030, IRS is pegged to lose about 50,000 agents. So it's not a net gain of 87,000. It's a net gain, if they hire all of those, of about 37,000. And the problem I have with that, Greg, you and I talked about this last time, a case from Iowa where the agent took just an absurd position against a farmer that said, well, because you use a bunch of old tractors, obviously you're not a farmer, you're an antique collector. That is one of the dumbest arguments I have heard IRS make with respect to farming in my career. My fear, Greg, with this is when they hire these agents, those agents have to be trained. And they can only be trained by the seasoned agents who then have to be pulled out of the field. And then when you have these new agents that start out, the history has shown that they tend to be pretty aggressive to try to impress their managers and move up the IRS food chain. And I just see a whole host of problems, particularly in the farm sector, because farm tax is so unique. And there are lots of difficult rules and lots of rules that people just, including IRS, are generally not familiar with unless they're specifically trained in it. So this could be an absolute night for us in future years with respect to audits concerning farm and ranch people.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is joining us. And reviewing some of the big cases concerning ag law and tax during 2022. And Roger, another one that is still going, or constantly going, I guess, in this case, and how many times have we visited this? The Waters of the United States rule, that's a case that's currently pending before this Supreme Court, looking at the definition and the administrative agencies who have been writing the new rule.
Yeah, that's right. That big issue in 23, and it was a huge issue in 22. Actually, this has been a big issue for a number of years. Of course, we had, if you go back to 1985, the courts really started cranking out decisions on what is a navigable water of the United States that gives the federal government jurisdiction. And that's an important issue for farmers and ranchers, because if you have a jurisdictional wind on your farm, that can really impact your farming practices. So how the feds define this for purposes of the Clean Water Act is really important. Well, the court started dealing with the Clean Water Act definition with cases beginning in the late 1970s. Of course, that definition came in 1972. And there have been just a tremendous amount of court cases over the years, and it really kind of left farmers in the lurch. Well, about 20 years ago, the U.S. Supreme Court tried to give clarity to this issue, and they came out with a very, pardon the pun, a muddied. It was all over the board. There were multiple opinions in the case, and it really left the district courts and the appellate courts with a big struggle as to how to define and what, in fact, what part of that opinion are they going to follow? There was really no clear majority opinion. Well, the Obama administration came in and wrote a rule that agriculture didn't like, really giving the feds jurisdiction over more private property. Dry ephemeral streams could be subject to the Clean Water Act. And then the Trump administration changed that, much more favorable rule, in my view, a much more common sense rule as to what is a wetland. You would think a wetland has to be wet, so let's start from that proposition. And then, of course, that has changed with another administration that is trying to rewrite the rule. And in the meantime, we've had litigation on all these different definitions. And there's a case from Idaho that's currently before the U.S. Supreme Court. And now it's not an ag case, but ag is watching it very closely because it goes back to what a definition is. And we're going to see who gets there first, whether it's going to be the Supreme Court or the administrative agency. If the administrative agency, the Corps and the EPA, define the rule first, then we'll have to see whether the Supreme Court basically changes that. It's ultimately going to be the Supreme Court's decision as to what the definition is. Huge issue, big issue for agriculture in 22, going to continue to be one, obviously, in 23.
On the Sackett versus EPA case, I assume it's probably hard to know a timeline of when they may decide on that. Is there a target area or a time period that we could see that decision on that case come down?
Yeah, that's that Idaho case I referenced. And I think probably February or March, if I'm reading the tea leaves correctly, that's when I think we'll see it. I don't think we'll have to the end of the Supreme Court's term. It was one of the very first cases argued on this term of the Supreme Court in early October. And so I think probably gets us for a decision February or March. So, give it a couple more months and we'll probably have that decision.
All right, another case I want to talk about that has been ongoing and will continue to be ongoing is the Proposition 12 case. Of course, Prop 12 out of the state of California. Then they're trying to set pork production rules, in essence, basically for the rest of the country.
Yeah, they are. This is presently pending at the U.S. Supreme Court, also argued in early October, just before the middle of October. And again, probably the timeline on this one would be February, maybe into March, when we'll see an opinion on this. Very interesting oral arguments in this case. Clearly, the U.S. Supreme Court is trying to thread the needle on this one to figure out how we respect what California wants to do, but then prevent other states from reacting to California and doing the same thing to California, saying you can't sell into our states unless you produce what you produce in ways that we approve of. And that's a tough question. It involves what's known as the Dormant Commerce Clause, which we have probably at least two justices that don't believe even exists. And so I'm not sure how they're going to decide this one, but clearly the justices were not entirely agreeing with the state of California. They also didn't entirely agree with the other side. And so that's why I think they're trying to find a middle ground here where states can set their own rules, but have a very minimal burdensome effect on commerce in other states. Now, in other words, California shouldn't be able to dictate how, in this instance, for example, pork is produced in Kansas or particularly in Iowa or other states. That's up to those states to set their own rules. And by the way, we do have overriding federal rules that deal with health and safety with respect to meat products. And so that's wound in here, too. It's not just California saying, well, we have concerns about the health and safety of our citizens based on these so-called immoral production practices that Iowans use in producing pork. Well, they're overriding federal rules that have to be satisfied, too. So it's going to be a very interesting case to see how the Supreme Court decides that one, of monumental importance to agriculture. That was big in 22. That's also going to be big in 23.
Just because of the marketing of the product,
Right.
game changer may not be the proper term, but nonetheless of potentially how that could end up being for any of these. And you go back to Iowa as a top pork producing state on what they're going to be able to do.
Yeah, that's right. And this decision would have tentacles outside of agriculture, too, because if one state is able to govern the production practices of a product in another state, that's not just limited to meat products. That can extend to all types of things. And the Supreme Court's got a tough job on their out. What does the Constitution allow a state to do in this instance without discriminating against out-of-state commerce? That's the really core question.
All right, and this is why for the end of the year review of everything, it's going to take us a bit. So, Roger, we got the first one done, but we've got a lot more yet to talk about on some of the review of 2022.
Yeah, we may have a Supreme Court opinion on one or both of these cases by the time we get done with all this stuff, Greg.
All right. Hey, Roger, as always, appreciate it, and we'll talk to you in the new year.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.